YouTube, it's Tone. I'm back with another one for you. Now this one is called the Foreclosure Defense Handbook, written by a dude named Vince Kahn, apparently with a place called Consumer Defense Programs. There's some links on the pages here too, and I'll put it in the in the description, and that'll show you how to get in contact with these people if you want any further information or even some updated information. Right, so let's go ahead and get down to the introduction. So I'm gonna skip the table of contents because there's a lot of bullshit there. So right here we got the introduction. So here you got the introduction. So by now you should know that we are in the middle of a global economic depression that was caused by the collapse of the housing market. What you probably didn't know is that all the events that led to the housing bubble collapse and the massive fraud committed by banks. This book hopes to help you connect the dots, specifically how to relate to foreclosure and how banks are committing fraud every single day by stealing homes from everyday people like you and me. Until now, this information was reserved only for the top echelon bankers that don't want you to have this information. If more people knew about this fraud, then our banker friends would be in jail. And I can almost guarantee you that these motherfuckers would be in jail if everybody really knew about this shit. But they have everybody acting, and they're just so used to rubber stamping shit in court and just thinking that everybody's crazy. Then you got people that halfway study and go to court and start making everybody that studies this information look like fucking assholes. And I'd imagine that some of them are agents that they send in there to spit stupid ass game, and they fucking record it and make everybody look like dickheads. But I've been studying this shit for a long time, and that whole fucking mortgage game is 100% complete fraud. Complete fraud. And we're gonna get into it because in this book we go over some of the codes and statutes that prove that these clowns are fucking committing this fraud. But also we go over some of the UCC information and all that as well. And this will all help you if you ever end up in court, or even give you information out of this book in order for you to put together something nice if you want to sue these people. Okay? Because I mean, when you start doing a administrative process on them, they don't even answer anything. So they're gonna back right into your position. You get your summary judgment, then go to court and have them bang the hammer on that. Okay? So right here, we are currently faced with the ghost towns all over the country where entire subdivisions have been foreclosed. Many communities have collapsed as a result of the depression. At this time, we have thousands and thousands of families living in tent cities because they have nowhere else to go. The worst part of this is only the beginning. It is projected that 2011-2012 will be even more devastating in terms of the number of foreclosures that are projected to take place, as many of the adjustable mortgages are nearing the end of their romance period. Tragically, over 85% of foreclosures have been and are being done fraudulently due to ignorance. We want to educate you so you can arm yourself with knowledge to defend your home. This ebook was written because we got tired of banks getting away with murder. We decided to research this topic and expose bank fraud in a manner that the average person can understand. And you know that that's what I do on this channel. I break it down in layman's terms so you can understand, because a lot of their fraud is hidden behind some fancy ass fucking language, and the shit is unnecessary. Okay? So this ebook was written because we got tired of, oh yeah, so I just read that. Even if you are in good standing, this book is something you should know about. Who knows? You could be one of the ones who might lose their jobs in the coming months as the global economic depression worsens. And like I said, this information will help you put together something nice to be able to sue these people, even if you are in good standing. And it's not against the law to investigate, you know, the terms and conditions of your mortgage, and to look into the details to make sure everything was done properly. So if you are one of those people trying to negotiate with your banks to do a loan modification, you must read this book. This is especially important if you are one of those people who have an upside down loan where you owe more than your house is worth. So those are the different types of people that can benefit, but I promise you everybody can benefit. Just stick with me and you're going to see what this shit's all about. I'll break it down nice for you. So this book applies to all home loans, whether it is a first, second, or home equity line of credit, a HELOC. It applies whether you are in a judicial or non-judicial state. We are going to show you where the fraud begins. We just ask that you keep an open mind. I'm pretty sure if you're on this channel, your mind's pretty fucking wide open by this point. So how to use this book. The problem with foreclosure crisis is everyone is in crisis mode. The homeowners lost their job due to economy. They are facing credit card companies chasing them, having to fight for a roof over their heads, and trying to keep it together at the same time. The banks are in a rush to foreclose the homes at all costs, regardless of ethics, procedure, ownership, or standings. And that's the biggest shit too, is knowing that these people never even had standing to foreclose in the first place, because they're not the holder in due course, and they can never produce the actual debt instrument that they actually need to have physical possession of in order to even send you a fucking bill. Okay, so amongst all this rush, no one ever stopped to talk about the gigantic white elephant in the room. The courts are also buried by foreclosure cases, which they want to rubber stamp these cases and ignore their oaths of office, which is afford to justice to all equally. So, and that's one of the things that you got to be careful with too, because they like to hide stupid shit with fancy words. So when they talk about equity and they want to treat everybody equal, it doesn't mean that they want to help you out. It means that they want to fuck everybody equally. Okay, so keep that in mind. So the same premise. All right, so where are we at? So remember Abbott and Costello's famous skit, Who's On First? The same premise can be applied to many of these bank foreclosures. In other words, who has proper standing to enforce the promissory note? Everyone just assumes that the bank are in this position. Judges are too busy to research this stuff. And it really is your job to do the research, because nobody gives a fuck about you, and it is your life, okay? So lawyers are too arrogant to acknowledge that there is something deeper at play here than a bunch of deadbeat homeowners trying to get out of their debt obligations. The most frustrating of all, this sort of information is not readily available in layman's terms and concepts so that everyone can understand. This is why we wrote this book. We have read thousands and thousands of pages full of information about this subject. It is only after one has immersed oneself enough in the subject and understands it intimately can one explain it in the most simplistic and elegant terms. We believe this book can be a good starting point for many to help them understand the nature of the bank fraud. Alright, excuse me, I'm writing down the times here for the slides. So let's get to the next joint. So we hope that you can take this book and give it to your lawyer and have him or her read it and get it. We hope that you can send this to your local journalist so that they can run a story about loan fraud so that more people will wake up. We hope that you can pass this to as many of your friends as possible so they too can get it. We intend for this book to be a simple tool to help open the people's eyes to one of the biggest frauds perpetrated by bankers in the history of mankind. We hope you will join us. Who is Vince Kahn? I am not a banker, lawyer, expert, or anything. I am a real estate investor who got caught in the housing bubble like everyone else. I am just an average homeowner who discovered the fraud and wanted to share my discovery with you and allow you to come to your own conclusions. I fell into default and started to challenge my bank to compel them to prove their standing. After sending a notice of default and filing for a trustee sale, they issued a rescission of the notice of default and stopped their foreclosure proceeding indefinitely. You can see the notice on the next page. I wrote this book at great risk to myself. Honestly, I feared for my life. I don't know why this dude's scared, and you guys should not be scared of these motherfuckers either, okay? So the fraud you are about to witness is something because they all fit in fucking trunks. You know what I'm saying? That's why you should not be scared of these people. So the fraud you are about to witness is something bankers have been trying to keep quiet for years. Court cases have been sealed because they do not want this information released and circulated into the general public. Homeowners have been given massive settlements on the condition of a gag order so the bankers can continue to do their dirty business. One expert witness we have interviewed even had his life threatened because of what he knows. I do not exaggerate when we say bankers will go to and have gone to any lengths to keep this information away from the general public. If this information gets widely circulated, many bankers will go to jail. The information contained in this book will potentially cause trillions of dollars in damages to the banking industry, which is complete bullshit. No, the fuck it won't. The shit's all monopoly money. Alright? So I felt that once this information had reached a critical mass, then it would be too late for the bankers to do any harm to me. So this dude's clearly fucking scared for his life, which is sad. Trust me, you guys do not gotta be scared of these motherfuckers. They're not gonna do shit. So I got tired of seeing people suffer from this fraud that I felt compelled to share my discovery to the public. I hope I can make a difference. I hope that you would join our movement and awaken other bankers to the fraud. So here we got a picture of dude's what do you call it? A picture of the rescission letter that the bank sent to him. When he started filing the paperwork. They just basically back the fuck up. Which is what they do. I'm in the middle of doing this right now to some banks, and they're not answering shit. I'm sending them all affidavits, administrative process. We're backing them right into the corner and setting our own stipulations, okay? So understand the securitization process. To fully comprehend the Carney wizardry and myth that encompasses the securitization process in relation to the right to enforce a negotiable instrument, which is a promissory note, this chapter is designed to support the legal argument behind who is the real and beneficial party of interest. This shit is extremely interesting, guys. You guys are gonna like this shit. So, background and introduction. In 1993, the Glass-Steagall Act was enacted to regulate the FDIC and banking specifically. It governed the protection of depositors' money so that banks were not allowed to gamble with the money in their safekeeping. This means that banks could not trade their assets on Wall Street. In 1999, the Glass-Steagall Act was repealed and another bill was introduced known as the Graham-Leach-Bliley Act. This effectively allowed banks to package and securitize their loans onto Wall Street. This means that suddenly the trillions of dollars from Wall Street could be used to fund loans. This is a good thing. This means that more loans were available to more people. This means that the retirement funds, the hedge funds, and all sorts of institutional investors had a safe place to park their money. These safe places would come to be known as mortgage-backed securities, MBS. This is also a good thing. These institutions demanded banks make these mortgage-backed securities packages available to them. These institutions rely on the following. Number one, the bank's banking license. Number two, the bank's underwriting process. Number three, the bank's collections infrastructure. So this is how these criminals began to essentially put together their fraudulent ass scheme. So let me write this slide down. Alright, so things started to break down when banks realized that since they are not required to be left holding the bag at the end of the day, they could simply underwrite any old loan from any idiot who can sign their name onto the paper. And I mean, that is the value of every loan and every transaction. You're not getting away from signing something, whether it's digital by putting your password or your PIN in, something like that, a digital signature. You got to sign because your signature is the value, okay? So banks decided to change their underwriting guidelines around 2001, 2002, the Bush era. This is where things started to go downhill. This means any McDonald's burger flipper could go down to the bank and get a loan for $1 million with no money down. No offense to those working in the fast food industry. These were commonly known as liar loans in the mortgage industries. This is great for low-income earners as long as the housing market is in a boom growth curve. This gets really bad in a housing bubble where the price of housing is way beyond the affordability index of most individuals' median income. Incentive and motivation of securitization. When a bank lends you money, they traditionally get 2.5 times the face value of the loan over 30 years. That's not bad considering that they did not use a single red cent of their own money. It is all digitally created through the Federal Reserve System. Read Modern Money Mechanics, published by the Federal Reserve. Also, get my book, Magic Money Mechanic, created by yours truly. So, for example, if you borrowed $100,000 over 30 years, you will have paid around $350,000 to the bank. Look at the Truth in Lending Disclosure Statement from your loan documents. Because of the Graham-Leach-Bliley Act, banks are now able to sell mortgage-backed securities. Some bright people at Goldman Sachs and others in the financial industry came to the conclusion that they could make even more money if they could sell loans on Wall Street. And so they did. This book is the story of what happened. Instead of making 2.5 times over 30 years from money they did not put up, banks decided they could make 1.5 times the face value of the loan immediately. Just package these loans and sell them on Wall Street. As the market grew, They not only made money from the sale, but also made money from the appreciation of the stock, which they are allowed to hold up to 10% of the security to qualify as a sale under the financial accounting standards. Okay, so what they're doing is securitizing everybody's mortgages, and once it is converted into a stock or bond, it is no longer a promissory note. So these people have essentially forfeited their position as holder in due course, which means that they can no longer ask you to fucking pay, let alone foreclose on your house. Okay, so I know you guys are understanding this. I know you understand this. So let me write this down. So the game of greed. Under the fractional reserve system, a bank can lend up to 9 times the face value of their depositors' money or cash reserves. Instead of receiving 2.5 times over 30 years for the loan, banks suddenly realized that they could make even more money if they sold the loan and received the cash now. So from that $100,000 loan, they receive $150,000 cash. This is treated as a deposit, which means they can now lend out $1.35 million, 9 times the $150,000, and do it again and again. Lather, rinse, and repeat. This is really good for the bank. This is really good for borrowers, as there is a sudden glut of unlimited money to borrow from. This is really bad for the economy in the long run, as we will see. If you study basic economics 101 in high school, you will know that if you have too much money chasing limited goods, it leads to an increase in prices. Well, this is exactly what happened. The banks threw their underwriting guidelines out the window. They had what's called a fiduciary responsibility to ensure that the loans were properly underwritten. This means that they were supposed to make sure that the loans they underwrote are backed by people who could actually afford to pay it back. Instead, they just ignored these underwriting guidelines in the name of greed. The banks knew that the loans were destined for Wall Street and that they were not going to keep the loans. So it suddenly became a game of hot potato, as it became someone else's problems. They basically stuck it to Wall Street. This means they stuck it to your retirement fund, your stock portfolio, and your life insurance portfolio. It was the perfect setup for the biggest financial meltdown in the history of mankind. It was the perfect storm. Before we get into the financial meltdown of 2008 2009, so hang on, let's talk about this. Alright, we're going to go ahead and skip that. Okay. So here we have a little example of like a little flow chart here, just showing you all of the different stages of the loans and how they all work there. So stage 1, the pooling and servicing agreement process. Once a loan is closed, it quickly gets put into a pooling and service agreement. This is then registered in the SEC as a Remic trust. The Remic stands for Real Estate Mortgage Investment Conduit. It is known as a special purpose vehicle for the purpose of tax exemption purposes. I will explain why this is important in stage 3. They appoint a master servicer of the Remic and a trustee to manage the trust. Normally, the trustee of the trust has the power and responsibility to administer the assets of the trust. For example, back in the feudal lord days, these lords would create trusts to put their assets in, such as their land, their castle, and so on. In the event that something happened to the lord, the trustee had the power to manage the estate or the trust. However, in the case of a Remic, the trust does not have the power to manage the assets of the trust. We will discuss in stage 3 how this is different. I'm just writing these numbers down. Hang on a second. Alright, so once the Remic is formed, it then gets converted into a security that is traded on Wall Street. This makes more sense later when I explain the relationship between an investor and a shareholder and a Remic. The changing of the state of the negotiable instrument. So this is when they convert the instrument from a promissory note into a stock, and they register it with the Securities Exchange Commission. Now it's converted into that. The mortgage is discharged. It's fucking done, okay? Know that. So imagine, if you will, that your loan is a carrot. It gets thrown in with thousands of other carrots into a giant juicing machine called a Remic. At the end of the process, you will get gallons and gallons of carrot juice. This juice is then sold to hundreds of people. So what they're doing is pulling them all together, and then they're selling it to a bunch of freaking investors who are willing to wait the amount of time that they didn't want to wait for the maturity of the note. So this is what happens when your loan. This is what happens to your loan when it gets securitized. Your loan is now owned by thousands of shareholders all over the world. Okay? So furthermore, the state of the loan has changed. Your loan has been converted into a stock. This is really, really important. Please spend a moment to understand this. Reread the section several times if you need to. Your loan is no more. It is now forever a stock. In other words, you cannot make a carrot from carrot juice. What's done is done and can never be undone. Once a loan has been securitized, it forever loses its security, the deed of trust, or the ability for the bank to foreclose on your house. This will be explained and changed in stage 3. This is why I say that over 85% of foreclosures are done fraudulently. A loan is what's called a negotiable instrument. There are specific laws governing negotiable instruments called the Uniform Commercial Code. Specifically, the right for a bank to enforce and foreclose on a property is subject to the claimant being a real party of interest. And you know what's funny about that? There never is a real party of interest. When you go to court, the bank sends their fucking lawyer in there to speak on behalf of the bank. There is no real, physical, tangible party of interest. The bank is a fucking fictitious entity, and it only exists on paper and in your mind. Now, when you go to court, you always have the right to face your freaking accuser, don't you? So, if you ever went in there just for shits and giggles, why don't you ask for the bank to please stand and raise their right hand and testify under the penalty of perjury? It can't do that because the bank is not a real thing, okay? So how the fuck could it be a real party of interest? The answer is it cannot be, okay? So if the loan has been sold, then the bank can no longer claim that they are a real party of interest, and that's another reason why they can't be a real party of interest. All right? So keep that in mind as we go down here. Now let me write this down. Okay. So we go to the next page. So not only that, once a loan has been converted into a stock, it is no longer a loan. If both the loan and the stock exist at the same time, that is known as double dipping. Double dipping is a form of securities fraud. A negotiable instrument can only be in one of the two states when it undergoes securitization, not both at the same time. It can either be a loan and treated and governed as such, or a stock and treated and governed as such. Once it is traded as a stock, it is forever a stock. It is treated as a stock and regulated by the Securities Exchange Commission as a stock. On the deed of trust of mortgage, it has language that says something like, this deed of trust secures a promissory note. Okay, listen, when this promissory note got converted into a stock, that promissory note no longer exists. If a trust was created to secure a promissory note, and that promissory note was destroyed, then that trust is invalid. The trust secures nothing. They literally need the original wet ink signed promissory note to be considered a real party of interest and the holder in due course. They never had that shit, alright? So the deed of the trust is what your lender uses to give them the right to foreclose on your house. If the deed of trust is invalid, then the lender loses their right to foreclose on your home. You see what the fuck's going on? So stage 3, the real parties of interest. Let's talk about accounting rules, specifically the rule governing a sale. To prevent accounting fraud, various governing bodies created financial accounting standards, FAS, and as you know, accounting is a very important area that needs to be regulated tightly to prevent companies from cooking the books. Specifically, FAS 140 was created to govern the sale and securitization of a negotiable instrument. Look it up. Google FAS 140. One of the things about FAS 140 is the rule governing a sale. A transaction can only be recognized as a sale if it is sold to a party at arm's length. In other words, you cannot sell an asset to yourself. This is what Enron did to hide their losses. Also, it says, and I am paraphrasing, that once an asset is sold, the seller forever loses the ability to control the asset. To illustrate this point, imagine if I were to sell you a brand new laptop. You took the laptop and smashed it into a million bits with a sledgehammer. Because I sold you the laptop, I have no say whatsoever about what you do with it. It's yours. This is really important to understand. Once an asset has been sold, the seller forever loses control of the asset. So you see what's going on, right? I know you can see what's going on here with this nonsense. So let me write down this time. All right. So what this means is, if your lender sold your loan to a Remic, then they forever lose their ability to enforce, control, or otherwise foreclose on your property. Put simply, they are no longer the real party of interest. They are just a servicer. So who are the real and beneficial parties of interest? Before we can properly answer this question, we have to discuss IRS tax codes. You see, the real party of interest has to pay taxes on their earnings. In other words, if your bank owns a note, they have to pay the tax on the interest earned from that note. If a Remic owns your note, then the Remic has a tax liability. The case of double taxation, corporations have known for years about double taxation. This means at a corporate level, at the end of the year, they take all of the revenue and subtract the expenses. What's left are the profits. These profits are then taxed. The corporation also has shareholders. The corporation typically distributes dividends to their shareholders. Once the shareholders receive the dividends, this is considered to be income to the shareholders. This is also taxed. In other words, profits are taxed twice. So you see what it is, right? So to avoid the problem of double taxation, banks put these loans into SPVs, special purpose vehicles, so they don't get taxed on them. This is covered under the Internal Revenue Code 860. This way, only the shareholders are taxed. This means only the shareholders are the real party of interest. You see what that is. So in the previous section, I discussed the powers of the trustee because of the special IRS rules. The trustee is not the real and beneficial party of interest because the Remic does not own the notes. The shareholders do. Therefore, they cannot enforce the promissory note. In other words, they can't have their cake and eat it too. They can either accept double taxation and let the Remic hold their centralized power, or they can distribute the tax liabilities to the shareholders, in which case they have also distributed the parties of interest. The bank chose to have a distributed party of interest scheme to avoid paying taxes twice. There is nothing wrong with this. But now they have a real pickle. If no one entity is a real and beneficial party of interest, then each and every shareholder of the Remic is. So then the question is, who has the right to foreclose? The answer is no one. Alright? So the answer is no one. So I want you guys to keep this in mind. I'm going to stop the video here so your attention span is, something tolerable. And there'll be a few more videos on this. The book's not done. If you want the book, email me for free. sovereignproductions369@gmail.com. Attention, Tony Tone. You guys know what it is. It is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.